It is my pleasure and my honor to deliver this message. My name is Cecilia Jimenez Damari, an international human rights lawyer and practitioner on the issue of forced displacement and migration, including internal displacement. And I am also the former Special Rapporteur on the human rights of internally displaced persons appointed by the United Nations from 2016 to 2022. As a Special Rapporteur, and upon the invitation of the government of Japan, I visited Japan from September 26 to October 7, 2022. During this time, I had consultative meetings with the Japanese government at city, district, prefecture, and national levels. I also heard from members of the parliament, including former MPs. And I received numerous testimonies from the evacuees, civil society, and lawyers, aside from visiting Fukushima Prefecture itself in 2 days. The official visit aimed at assessing the situation of the human rights of the so-called, quote, evacuees, unquote, more appropriately called internally displaced persons, from the Fukushima disaster of 2011. The report I submitted to the United Nations Human Rights Council in June 2023 contained a thorough assessment of the human rights of the evacuees or internally displaced persons in accordance with international standards, and also contained consequent important recommendations based on good practice. The Fukushima Daiichi nuclear disaster following the Great East Japan earthquake and tsunami of March 2011 was indeed a devastating and unprecedented event in the country's history, forcibly displacing more than 470,000 persons, while the majority of those displaced have since returned home or resettled. Thousands of persons displaced by the nuclear disaster unfortunately continue to face uncertain futures due to fears over radiation and its uncertain long-term impact on health, as well as concerns over basic services. My report to the UN Human Rights Council and address to the government of Japan recommended the following. In the conclusions, we will find the following. Paragraph 96. In the face of an unprecedented disaster, Japan is to be commended for the rapidity and the scale of its emergency response, the establishment of multiple channels for internally displaced persons to claim compensation and support for such persons in the aftermath of the disaster, provided by federal and prefectural authorities. However, protection and assistance measures, notably housing assistance and compensation for emotional distress, have diminished over time as the authorities shift focus to reconstruction and reopening the prefecture, despite associated human rights challenges. Evacuees who prefer to remain displaced, particularly voluntary evacuees, and who receive less support, feel under financial and social pressure to return. Paragraph 97 says, all evacuees from Fukushima, whether displaced because of evacuation orders or fear of the nuclear disaster's effects, are internally displaced persons with the same rights. All internally displaced persons have the right to an informed and voluntary decision on which durable solution to pursue, which emanates from the right to freedom of movement and residence. The guiding principles on internal displacement establish the rights of all internally displaced persons to seek safety in another part of the country and to be protected against forcible return to any place in which their life or health would be at risk. and that governments bear the primary duty and responsibility for ensuring conditions that allow internally displaced persons to return voluntarily, safely, and in dignity, or to resettle voluntarily elsewhere. The safety and equal protection of all Japanese citizens is guaranteed under the Constitution. Paragraph 98. The framework on durable solutions for internally displaced persons obliges authorities to ensure that IDPs can exercise this choice without coercion, including tacit forms of coercion, such as the provision of erroneous and deliberately misleading information, making assistance conditional on specific choices, and setting arbitrary time limits to end assistance before the minimum conditions conducive for durable solutions are established. In this light, providing only reassuring information on radiation, disbursing more generous assistance to returnees than those in displacement, and ending assistance to IDPs before conditions are fully conducive to return run contrary to international law standards and infringe upon the rights of such persons to evacuation and to a durable solution of their choice. Paragraph 99 proceeds. In the context of the Fukushima disaster, many IDPs remain reluctant to return given the levels of radiation with uncertain long-term impacts, the lack of livelihoods, education, health, and essential services in areas of return, and the limited extent of decontamination, challenges that also affect the human rights of IDPs who do return. Addressing these issues rather than papering over them is critical to ensure the durability of solutions and the recovery. It is also important to recognize that many IDPs may exercise the right to settle permanently elsewhere in Japan. These internally displaced persons should not face discrimination for this choice and should receive support and compensation on equal terms, regardless of whether their displacement was voluntary or mandatory, to enable their settlement. Paragraph 11. As an overall recommendation, the Special Rapporteur urges the government of Japan to categorically adopt a human rights-based approach to protection, humanitarian assistance, and durable solutions for all persons internally displaced by the Fukushima disaster, with a particular focus on those who are still displaced. Paragraph 101. Underlying this, the Special Rapporteur strongly recommends that the discriminatory distinction between mandatory and voluntary internally displaced persons be completely eliminated in all administrative and legal policies and their actual implementation. Paragraph 102. In line with the international human rights commitments of Japan, the guiding principles on internal displacement, and the framework on durable solutions for internally displaced persons, the Special Rapporteur reiterates the recommendations made in Section 5 to address the specific human rights challenges faced by the displaced persons from Fukushima. And these, by the way, include recommendations for particular sectors of the IDPs from Fukushima, including children, women, and single-headed households. Now, I was told that these recommendations have been translated by the citizens groups that supported my visit to Japan. Thank you very much. This translation have also been posted on their website and pressed as a booklet, and is currently being used in court cases and university classes. It is heartwarming to know that despite the ongoing dire situation of internally displaced persons and victims of the Fukushima Daiichi nuclear disaster, you are all continuing to fight for the rights of the victims and are using my official report to assist in this purpose. Unfortunately, I have also been informed that the Japanese government has not accepted the recommendations, nor have they improved the situation of the human rights of the Fukushima IDPs, despite the fact that it has stated to agree to follow up on the report. I am disappointed as well that the Japanese judicial authorities have effectively dismissed the findings which are based not only on the on-the-ground assessment I conducted, but also on interpretation of international law in accordance with the international human rights standards that Japan is obliged to follow. I am also informed that Fukushima Prefecture has argued in court that the guiding principles on internally displaced persons are merely an opinion prepared by a single UN committee. This is wrong, and that it cannot be considered a source of law such as a treaty or customary international law. It also said that the report has no legally binding force. This is an astonishing and misguided perception of international law, as it does not reflect the actual international endorsement of the guiding principles as a composite framework of primarily binding international norms already found in use cogents and in treaty law. Neither does this perception understand that, yes, while the recommendations of the UN Special Rapporteurs are indeed called recommendations, they are nevertheless recommendations based on actual implementation of international human rights law on the reality on the ground. The post-investigation statement of the United Nations Working Group on Human Rights and Business in August 2023 actually even pointed out problems in the sections on access to remedies and national judicial mechanisms. The UN Working Group on Human Rights and Business strongly recommended the mandatory implementation of extensive human rights training for judges and lawyers, with which I strongly agree. Special rapporteurs are experts appointed by the UN Human Rights Council to investigate, monitor, report, and make recommendations on the human rights situation of a particular country or subject matter. They serve in an individual capacity independent of any government or organization and receive no salary or other financial compensation, so that they will be enabled to perform their duties neutrally. In particular, they use information from their visits, namely from the government, private sector, non-governmental organizations, and victims, to address the human rights violations. The authority of this system is grounded in the United Nations Charter. The recommendations and opinions are based on international human rights standards, including the human rights treaties that Japan has also ratified and is obligated to implement, and thus represent international law. In other countries, governments have dialogued with the Special Rapporteur, accepted his or her recommendations, and improved the human rights situation in their own countries. They may also seek input from the Special Rapporteur when drafting new domestic legislation. In fact, a growing number of countries have specifically recognized and further incorporated the guiding principles on internal displacement in their national legislation. Japan is a country that frequently experiences large-scale natural disasters, and anyone can become internally displaced at any time. Disasters included, of course, the Fukushima nuclear incidents that occurred 14 years ago. Such disasters extend, but certainly not limited, to possible pollution incidents. Ensuring that the people of Japan are guaranteed their human rights and can live in dignity in the event of internal displacement is actually the primary responsibility of the government of Japan, and Japan as a member of the United Nations. Indeed, Japan, through its government, including the Fukushima Prefecture and relevant local governments, executive agencies, and the judicial branch and its courts, have this national responsibility to implement under international law. To ensure that the human rights of the Fukushima evacuees is actually implemented and protected is a necessity now. The consequences of the internal displacement of Fukushima have not ended. Indeed, international policy on internally displaced persons affirm that so long as there remains displacement-related issues on the human rights experienced by the evacuees, that government responsibility to guarantee those human rights continues to be present. This is the case of the Fukushima evacuees 14 years hence. The recommendations emanating from the 2022 official visit report to Japan remain valid and need to be implemented. Thank you very much for your attention.